The Marketable Record Title Act, I'm going to call it MARTA, is a law that is designed to remove stale claims from the chain of title. Sounds innocent enough. It says that if there's a restriction in a chain of title and it's not actually expressed in the body of a deed, then it will die after 30 years. Now there's a lot more nuances to that, but just keep that in mind. In the case of homeowner associations in particular, because condos, in every deed, they incorporate the declaration of condominium. So the declaration of condominium is never going to expire because of a Marketable Record Title Act issue. But in a homeowners association, unless the deeds specifically say Lot 5, Block 3 of Happy Land Estates, subject to that certain declaration of covenants recorded at book so-and-so, page so-and-so of the official records of whatever county, Florida, those restrictions will fall out of the title after 30 years from what's called root of title. So what does that mean? Lawyers got lazy a long time ago, and instead of saying in the body of a deed, subject to that certain easement in favor of so-and-so and subject to that certain restriction and subject to that mortgage, that all kind of moved to an exhibit to the title insurance, and there's a catch-all expression that says subject to easements, conditions, and covenants of record. Well, it's clear that that kind of language in a homeowner association deed will not allow covenants to survive. So what has the legislature done? What it hasn't done, which would be very easy, and I'm not sure I understand why the various stakeholders have objected to this, is say that community association restrictions are not subject to the Marketable Record Title Act, and that's the end of it. But no, there's two different ways of dealing with the issue of the possible expiration or expiration of documents under MARTA. Okay? If the documents have not expired yet, the board of directors can follow a procedure set forth in the statutes which provides that they can hold a board meeting and vote to continue the covenants, and as long as that's done according to the statute and it's recorded and proper hoops are jumped through, for lack of a more technical term, the documents will not expire after 30 years from root of title. If documents have expired, there is a process called revitalization. It's kind of like, I call it the Lazarus rule. We're bringing it back from the dead. Now, what happens there? It involves a lot more legal work, but not tremendous. We've averaged maybe $1,500 in legal fees in putting these things together, but it involves a lot of shoe leather, because what you've got to do is bring the documents, or deliver the documents to the owners, get the owners to agree in writing to revitalize them, and send it, I think, to the Department of Economic Opportunity. How they got stuck with this job, I don't know, but they did. And that takes longer and is more expensive than just a board meeting. But you'd be surprised, because lots of people don't know about this. My wife and I were shopping for a townhome on the beach, and I looked at the restrictions and saw that they were recorded in 1973, and by my math, it was well over 40 years since those documents were recorded. And they have an association. The association is active and current, but I saw nothing in the official records which gave me any indication that those covenants were either preserved or revitalized. Now, whose job is it to tell the buyer that the documents are expired? Real estate agents not obligated to say that. That's probably the practice of law anyway. Title company, they're not obligated to disclose anything. In fact, any flaw in title that arises out of the restrictions is specifically exempted from coverage under title insurance. The lawyer or title company doing the closing, you can have a perfectly fine closing without an active or enforceable set of deed restrictions. So it's a matter of, I guess, caveat emptor. Buyer beware. You have to be sophisticated enough to ask the question, how old are the covenants and have they expired? It's not on the seller's disclosure sheet, and most sellers, even if it was, wouldn't have a clue. So it's a matter of due diligence, but it's an important matter because I said to my wife, maybe it's good that we buy here because that way we'll just put an extra room on the lot. The lot ran from State Road A1A to the Atlantic Ocean. It's 25 feet wide and 250 feet long. But I said, I'm not buying in a community where there's no enforceable restrictions. There's no requirement to pay assessments. There's nothing. Yes, there's an association. Yes, there's a management company. But the restrictions haven't been revitalized. And as a result, mayhem could occur, the kind we see on those Allstate commercials. So be aware of mayhem. Don't let MARTA operate to either let your documents expire, and if you're going to buy property, make sure that MARTA has not operated to void those, because the only person looking out for MARTA expirations is you, unless you specifically ask someone to do so.